Hi! In this third and last video for this session, I want to briefly discuss general principles of international law, unilateral declarations, and subsidiary sources. Now, if you haven't watched the very first video on the general principles underlying the source doctrine and on customary international law, have a look at those first. And next session, we will actually talk in detail about treaties, so I have bracketed this question for the time being as well. Now, general principles of international law are actually a very important source, but one that doesn't sometimes receive the attention that is needed. That is so because on the one hand, treaties, what are sometimes referred to as the workhorses of international law, and custom together do the heavy lifting when it comes to the substantive obligations. But general principles are really important because they fill in the procedural gaps and create or turn the system of international law into a functioning legal system. To illustrate this role of general principles of international law, I sometimes use the image of the bricks and the mortar. So if treaty law and customary rules are the bricks, the sort of substantive core pieces of the building of international law, then general principles are the mortar, which hold everything together, which fill gap and which create a sort of cohesion between the various elements. In particular, if we don't know, for example, by means of a treaty law or custom, how to interpret or apply rules. In other words, general principles guide the interpretation and application of treaty rules and customary rules. They create a legal certainty. They also give us an indication of how judicial and administrative procedures are to be applied. All of this, of course, you can see is really crucial, and without it, international law wouldn't function the way it does. To give you one example to really drive home this point, let's look at the good faith principle. Good faith means that states can expect another state to actually really meaningfully and sincerely apply and abide by an international legal rule. So not to try to deliberately circumvent or abuse it. Without the principle of good faith, of course, the whole idea of state consent, of obligations, of international law in general would not make any sense. If you cannot presume that the other party in this kind of contractual relationship will abide by their obligations, well, then you will not engage in it. Another very logical principle of international law would be ex iniuria ius non oritur, which is a Latin phrase meaning that from an unjust or illegal act, no legal act can derive. So if you engage in something that is illegal, but that then gives you some sort of legal advantage, well, this legal advantage will not actually count. You will not be able to invoke your illegal act to then derive legal benefits from it. Again, a principle recognized across legal systems around the world and crucial, in fact indispensable for any rule of law system to work effectively. Moving on, and again looking at Article 38 of the ICJ statute, we also have the subsidiary sources. So judicial decisions and the publications of eminent scholars, i.e. academic publications that can help you, that work as subsidiary sources to help illustrate something about the other three sources that preceded in the ICJ statute. Now, it's really important to understand that a subsidiary source is not a standalone source. You cannot, for example, point to a book or point to a particular decision to say, well, this is international law as it stands. Rather, these subsidiary sources need to be invoked in conjunction with something else. And as such, of course, they're extremely relevant in practice. Think for a moment back to our discussion of customary international law rules and how difficult it is to prove whether the threshold of state practice has been reached or whether there's opinio juris. And looking at an academic publication can be very helpful in this regard if the scholar in question has done extensive research, looked at legislation and a judicial decision and its statements from government, from states across the world, to then come to a scientific conclusion that indeed a certain practice qualifies as custom. Similar use can of course be found when we look at general principles, but also at interpretation of treaties and how we need to correctly understand a particular word or particular context, things that we will talk and discuss in the next session. The next aspect to cover are unilateral acts. Relatively rare, and maybe you can already imagine from what you have heard so far why this is not a seamless fit in the international legal system. Usually when a state consents to be bound by an international legal obligation, it expects something in return, there is some sort of benefit that is derived from it, but even more importantly, this promise is made vis-a-vis a specific party, another state or multiple states, when it comes to, for example, multilateral treaties, as we'll see in the next session. Unilateral acts do not have this counterpart. There is nobody towards whom you are making this promise to live up to an obligation. However, the ICJ, notably in the nuclear test cases, has in fact confirmed that this can still happen. So in this particular case, France had unilaterally bound itself to stop nuclear testing in Polynesia and the South Sea. And in the end, this obligation was applicable because many government officials, high-ranking French government officials, had made declaration to the fact that showed that there was a legal obligation undergirding their statements, and that then was used by Australia and New Zealand. Last but not least, they use cogens norms, or what is sometimes also referred to as peremptory norms of international law. These are not so much a source, but rather a type of legal obligation. Specifically, it's a type of legal obligation that does not allow for any sort of derogations. So there is no circumstance in which it would be legally justified to engage in such behavior. What usually underlies the use cogens norm is some sort of moral understanding that this would be inherently wrong, such as, for example, and these are use cogens norms, the prohibition of genocide, the prohibition of inhumane and degrading treatment and torture, or the prohibition of slavery. There is just no circumstance under which the state can legitimately justify breaching these international legal norms. These norms are also therefore owed to all other states. So they are so-called erga omnes norms that are applicable among all states, the international community as a whole, which creates or gives them a sort of public law element. Considering all these aspects, the idea of use cogens was controversial for a long time, and even the ICJ did not acknowledge the existence of use cogens norms until very late. It has done so by now, referring to the examples I just gave. The criticism was that, well, you create a kind of hierarchy of international law norms in which some rules, such as the use cogens rules notably, are more important than others, whereas in fact it's all based on state consent, and the state is either subject to an obligation or not. By now, given the importance and kind of legitimacy of the rules that are recognized as use cogens, there is not that much criticism about it anymore. It has also been acknowledged in the Vienna Convention on the Law of Treaties, showing that states themselves, and that's of course the most important aspect of international law, that states themselves have also accepted that there are certain peremptory norms from which they cannot derogate. This concludes the videos for this week. I will be back next week with 3 clips regarding what's arguably the most important source of international law, namely treaties. Bye bye.